Okay, so I think only you were present in the lecture, yes? What about others? So what did you study yesterday? Did you study about common law and civil law? Can anyone tell me the difference between common law and civil law? Asal 204, Dildar, okay, you are speaking, yes. Ahmad, Durdona, guys, it is going to be very boring if you will not interact. What is the difference between common law and civil law? Yesterday you had a lecture. Anyone? Hello? You can also gappering. Why you are asking him to gappering? What about you? No? So what was not clear in the lecture? We can discuss that. You were present in the lecture, yes? All of you. Okay, now this question you should be answering yes or no. Yesterday you were present in the lecture. Okay. So what you did not understand? What you remember from the class?
So on the lecture, we have studied the two types of the, like, how can I say, the main ones, the common law and
legal system.
yes,
Yes.
Common law and civil law, and after that we have studied the classifications of law.
Okay, good. So what is I am asking from the colleagues that what is the difference between civil law and common law? How do you understand civil law and common law? I am not judging you. I just want to have an idea that what you have learned from the lecture. Okay. If you didn't learn anything, then we can repeat. I can review the lecture material, but I should have a genuine or honest feedback if you know something or not, or if you have interest in learning something or not. Okay. So that's why I'm asking you that was lecture clear, or you just didn't remember anything? Yes, in that case we can review the lecture if you don't want to do discussion. No, I think you just put on your Zoom and disappeared.
Well, the main difference between the two systems, let's say the common law and civil law, where how can I say, civil law is the system where we use the codes, and on well, the second was common law, in which we use judicial opinions, maybe like, for example, case law. It's more like has a primary importance. I understand all of this.
This was the lecture, yes?
Yes.
So the law is divided into civil law and common law. Civil law, as you correctly mentioned, that it is about the codified law or Roman German law. You might have heard about it, saying your teacher. So codified law or civil law or statutory law, what does it mean? It's mean that law is written in advance in the form of codes or articles. For example, you have Grajdansky Codex, you have Trudavoy Codex. So there are different articles, and these articles mention separate laws. Article 240 says, if you will do this, this will happen. If you will do this, this will happen. So everything is written in the form of codes, in the form of articles. This is civil law. And the common law is, there are not many codes. So each case is decided on its merit. So the judge listens to the case, the facts of the case, and give his judgment. Now this judgment is used as a law for future similar cases. Okay. So this is the difference between civil law and common law. You can say that civil law, in this, the big part of the law is decided beforehand, but in common law, the most of the law is made after the case in the form of judgment. So what is equity? Equity. Can anyone describe equity? How do you understand equity? So equity is fairness. Equity is equality, fairness. Okay. So sometimes the judge decides something based on his own understanding of fairness. For example, in the class, two students start fighting, and I, as a teacher, decide something among them based on fairness, then it will be called equity. So equity is when you decide something based on what will be the balanced, what will be the just approach. This is called as equity. It can happen in any legal system. So if you want to classify law, the law is classified mainly into criminal law and civil law. What does it mean by criminal law? Criminal law means the state has described that these actions are prohibited. None of the citizens should be doing any of these actions. If you will do this, it will be a crime. State has decided that you should not kill anyone. State has decided that you should not steal money, cheat anyone, do corruption. If you will do this, it will be considered as a crime. Okay. So these sort of things, these are dealt in the regime of criminal law. Now the civil law is, if there are disputes between two individuals, for example, I give money to someone, this person is not returning my money. If this person is not returning my money, I will go to the court. This case is now a civil dispute or civil law because this is between two people. Okay. Now you tell me, if someone is throwing garbage, or musar, or someone is littering the street, is it the substance matter of criminal law or civil law? What do you think? If someone is throwing garbage on the street, do you think it is criminal law or the question of civil law? What do you think? What is your opinion? Chat, someone has sent in the chat. Nigana Mano, you can use your microphone and you can speak. Okay, criminal. Why you don't want to speak? Why I should be speaking? I was told that our students are very active and they do discussions and blah blah blah. So it is totally opposite. Okay. So this is a criminal law because the state has made laws related to environment, laws related to cleanliness, law related to protection of ecology. So if someone is throwing garbage, it's mean that it is violating these laws. That's why it is a criminal law. But if you want to make it a civil law, it is very easy. Sometimes it happens that some people throw garbage in front of your door, in front of your home, in front of your flat. In this case, you can go to the police and you can write an application or zablini, or you can say that this person is throwing garbage in front of my house. Now it can be a civil law and criminal law. Yes, civil law, that now it is a dispute between two people. In this case, you can make a complaint. Okay. At least say okay.
Okay.
Okay, thank you. It gives me, this indication that we are still connected.
And by the way, can we call the civil law as a public law also?
So it depends on the situations. Public law is basically the interaction between state and individual. Okay, so it is more state oriented. State thinks about public. Okay, so civil law is basically between two individuals. In this sense, you can say civil law as a public law, that state has laws related to anti-monopoly or fairness or competition or dealing in businesses. Yes, so two-person, they are doing business, they cannot cheat each other. Yes, so in this sense, it is a dealing between two individuals, but it is a public law because there are laws. According to this law, they should act. You cannot decide that I want to sell my home to this person without involving government. Yes, you have to follow the procedure, you have to pay the tax, you have to register the contract. You cannot just simply say that, okay, I give you my house and you can give me the money. In this sense, the dealing is between two individuals, but state has interference. Okay, the state has laws related to property, the sale of property, and we should involve the state. So substantive law and procedural law. Substantive mean what law says about the things. For example, what law say about crime, what law say about property, what law says about you and me, about relationship, about anything. And procedural law is how you will implement the laws. For example, someone beats someone, or someone, shoot someone. This is a crime. This is a crime. Yes, murder or killing is a crime. So it is a substantive law. The law has defined what is crime and what is not crime. Procedural laws means through which procedure you will implement this law. For example, if someone shoots someone, what you will do, you will go to the police, you will write an application, Zablinia, FIR, first investigation report, or whatever you say. Then the police will start investigating the matter. Police will, arrest this culprit. Police will file a charge sheet, go, send him to the jail and so on. So these are the procedures. So the substance is the law, the content of law, the product of law. It is the what is what. And procedure is through which channel this law will be administered. Okay, so this is the difference between substantive law and procedural law. Now the public law and private law. The public law concerns the relationship between state and individuals and different state bodies and private bodies with regard to government. Okay, where there is government involved, you can say it is public law. And the private law is the rights and obligation between private individuals. For example, you want to marry with someone, government doesn't care. You can marry. If you want to sell something, you want to buy something, it is your freedom. Uh, but you cannot kill someone, you cannot cheat someone, you cannot rob someone. This is the public law. The government has made restrictions on it. Okay. And similarly, the common law or statute law. Now, keep in mind this statute law, codified law, Roman German law, or civil law, it is the same thing. Okay. Similarly, the common law, Anglo-Saxon law, they are the same thing. So in common law, judges make the law, and law developed by the decision of judges. For example, there is a case and judge has decided this case, judge has given the judgment. Now, if a similar case happens in future, you can refer to this previous judgment and you can say to the judge that, see, this case is similar to this case and this case has already been decided like this. Okay. Doctrine of precedent. This is the doctrine of precedent, that what has already been decided, it will be taken as an example in the next case. On the other side, statute law is the law made by the legislature, like Oli Majlis or the Chamber of Lawyers in some countries. In the parliament, they make these codified laws, ordinances, different acts, presidential decree, you can say. Okay. Then different internal organizations, they make their internal laws, vnutarni pravila, which you say, the rules of the board of directors which they make for a company. All of these things, these are statutory laws, means they are decided beforehand. Okay. So I told you the distinction between civil law and common law, that in civil law you can say that law is decided beforehand. In the common law you can say that law comes later when the incident happens. So difference between common law and equity. Common law, as we discussed already, that it is made by the lawmakers, judges mostly, or the king. And equity, I told you, it is about fairness, about fairness. If two people are fighting and one person say that he's not giving me 50,000 soms, okay? And I, as a judge, I say, please let him go because he doesn't have 50,000 soms, but you can take his mobile phone. His mobile phone is equal to 50,000 som. So there is no as such law, but I decided based on the fairness principle. So it's mean that it is the equity, that you try to balance somehow the situation. This is called as equity. Did you understand equity?
Yes.
Yeah. A more example, for example, you give $10,000 to someone and ask him that I want to buy your car and this is $10,000. Now this person, he spent these $10,000 and his car went into an accident and he is unable to pay you your money back. In this situation, the judge can say that he doesn't have car, he doesn't have your money, but he has a house which is worth $10,000. You can take his house. It will be a fair decision, okay? So as such, it is not written anywhere that if you don't pay your debt back, or if you are unable to give your product, then you should give the house. No, it is decided based upon the principle of fairness, that it will balance the situation. So this is called as equity. International law, the law between the governments, and municipal law is domestic law, the law of the land, the law of a country. Okay. Doctrine of precedent. What does it mean by doctrine of precedent? I already talked about it. That doctrine of precedent means the things which are decided by the judges, they will be used as an example in future. So what is the rationale? Rationale behind this is fairness and justice. That the judge should not be giving different opinions again and again in the same situation. Okay. Some things which has already been decided, they should be there and they should be followed. Judges follow the doctrine of precedent. These are binding, means they should be followed. And persuasive is a guide, not a must to follow. So sometimes it happens that there is a judgment and there is a law. So you will follow the law, which is a separate written in a document, instead of what the judge says. Okay. Yes. Stare decisis. Stare decisis is also related to precedent, that the things which has already been decided, you should not discuss them again and again. So, for example, husband and wife, they separated. and wife made a claim on husband for maintenance of the children. So wife say to the judge that I have babies and he has given me divorce and I cannot, take care of children are his children as well. So the judge say that okay, to the husband, you will pay him $300 every month until the child become the age of 7, for example. Yes. Now, if a similar case comes to the court in future, the court will follow the same precedent, that they will say in that course when husband and wife they had a dispute, the court decided in a way that the husband will give $300 for the maintenance of children. Yes. So there are two conditions. One is hierarchy of the court. Hierarchy of the court means if a judgment is given by the judge of a higher court, it has more worth than if a judgment is given by a lower court judge. Okay. So if a higher court has decided something, it will worth more rather than what has been decided by a lower court. So it should be reliable system of reporting and publishing the decision of the court. So when the judgments which are worth importance for everyone, judge say that please report it. And it's mean that it is published in different article in the form of article in different, journalistic medias, in academic journals, in books, it is reported and everyone knows that this judge has given this judgment about this case, so that everyone should know in future. Stare decisis, vertical stare decisis or horizontal stare decisis means vertical means higher court, Supreme Court's decision will be higher than the lower court decision. Yes, vertical hierarchy. Horizontal stare decisis, you can say in simple word, the courts are at the same level. For example, there is a court in Alaiski and a court in Mirabad. So the two judges give a decision, they are at same level. Then it happens that sometimes one case is decided by 2 or 3 judges in one court. So in this case, if the courts are same level, then we will see which court has more judges. Yes. So this is called as horizontal stare decisis. Means if the case is decided in the same court, then we will see which case has more volume, which case has more value. Yes, in terms of legal worthiness. So ratio decidendi versus arbitrary dicta. Ratio decidendi, arbitrary dicta, stare decisis, these are Latin terminologies. We extensively use this in our legal system. So did you take the notes when your lecturer was saying these words, ratio decidendi or arbitrary dicta? Do you know what is this? Hello? At least when you have these sort of words, you should take notes. No. It is not good. Yes. So I mean, if you are listening to the lecture and someone say ratio decidendi, yes, you should be attentive that what is this, because it is not in our language. Yes. So at least you should take notes about it. So first let's talk about arbiter dicta. Arbiter dicta is that when the judge gives a judgment or judge is writing a judgment, he writes or he speaks about law, and he also speaks about blah blah blah. He can give his own opinion, he can do the discussion, he can say that it shouldn't be this, it shouldn't be like this, out of law. Yes. So these things are called as arbiter dicta. Means there are so many things which judges say, which judges write, which does not have legal worth. Okay. Not everything what judge say is law. So ratio decidendi is more about responsibility and fairness, rationality. The judgment which is given by the judge should be rational. It should be logical. Okay. So ratio decidendi is more about rationality, more about logic. And arbiter dicta means whatever judge is saying, it is not law. It may be his personal opinion, maybe it is explanation of something. So we say that it is arbiter dicta in a judgment. Distinguishing cases, some cases they are used again and again. Some cases they become landmark cases. Some cases they become very famous cases. Okay. So we use them again and again, and we say that these are distinguishing cases. These are very famous cases. Guys, at least you should take notes of these terminologies when your lecturer is speaking, when you take lecture. So legal system, legislature or parliament, it is the lawmaking body. For example, in Uzbekistan, it is Oli Majlis, Parliament of Singapore, upper and lower house of the parliament in UK. Then there is executive or administration, execute the laws, has the power to administer and carry out the laws made by the legislature. They implement, for example, government of Uzbekistan, yes. And then you have judiciary. Judiciary supervises. Judiciary interpret. Judiciary has more supervisory role. It checks that law is being implemented or not, and it decide if there is a conflict of law. Okay, so this is the role of judiciary. Introduction to cases, civil cases. Who is a plaintiff? Plaintiff is the person who starts the cases. For example, if someone is not giving you your money, you go and start a case, you are a plaintiff. Defendant. Defendant is a person who is being sued. The person who owes you the money, he is the defendant. The third party, when you go into the court and you say that this person owes me $10,000, and this person say that no, I didn't take the money, it was that person. See, so he refers to a third person. Now the third party is involved. This is the third party. Yes. So counterclaim means sometime when you make a civil claim, the other party can also make a claim. For example, you say that this person owes me $10,000. You say to the judge, this person owes me $10,000. And the other person say, no, I don't owe him $10,000. He owes me $20,000. So it's mean that you made a claim and this person has made a counterclaim. Okay. So what happens in the criminal cases? Prosecution. The person who prosecute the case, it is the lawyer, and DPP, MOM, and LTA. These are in the Singapore. Yes, deputy public prosecutor, or these are the people who are present in the court on the behalf of government. You can say that these are the state salaried lawyers on the payroll of the government. Yes, state lawyer, you can say that. So they present the case of the government, they defend the case of the government. So DPP is public prosecutor, MOM, you can say it is the Ministry of Manpower, LTA, they are the labor courts in which they have these labor and transport related lawyers who represent the government. So accused is a person who is charged with the offense. Okay. So I am a person, I made a application in the police office, office that this person has beaten me. So I am accusing this person. This person, when he will present in the court, he will be accused. Accused of a crime means this person has committed this crime. Okay. Appellant, the person who is making the appeal. Respondent, the person who is responding. It is clear. Yes. So civil cases, what happens in the civil cases? Writ of summons. The court issues summons. The court calls a party. The court says to the party, please come to the court on this date. Service means they serve this notice to the parties that on this date you should present in the court. Serving the notice. Parties appear in the court, it is appearance. Then they defend, they counterclaim, they say he said this, we did this, he did this. Reply and defense to the counterclaim, yes, he owes me this, you owe me this, I owe you this, these sort of things. And when everything is discussed, then it is the close of pleading. Then it is closed for discussion. And then the court does the discovery. For example, sometimes they say, okay, they have done everything. Now you should discover more evidence. They can ask about documents. They can ask people to go. They can ask departments to give their opinion. Sometimes court can call an expert and expert can give his own advice and so on. Yes. So this is all the process of discovery. Affidavits. What are the affidavits? Affidavits are when you say something under oath, when you give a certificate of genuineness, you say that I give an oath that this statement is like this. According to my knowledge, this statement is true. Okay. So this is affidavit. It is kind of Natrayalni Zaverit. Trial is how the court proceeds. Judgment is judgment. If you are not satisfied with the judgment, then you can go to a higher court for appeal. Yes, is there any question? Who raised his question? Asal 204. Do you have any question? No? By mistake? Do you want to ask a question? No? Okay. So, criminal proceedings. What are the criminal proceedings? Criminal proceedings, if there is a culprit, the police arrest, then they do the investigation, then they charge him with the crime, then they file a statement of facts that what happened, then plea means the criminal can say that I was not there or I didn't do this, these sort of things. Yes. And the trial is in the court, and finding means the court finds who is right and who is wrong. This is the procedure for the criminal proceeding. Mitigation. So there is a word called as mitigation and there is a word which is called as mediation. Okay. So what is the difference between mitigation and mediation? Mitigation, first of all, mitigation, what is written here? Court reduce this punishment. Okay. So it is the process of reducing the punishment. For this purpose, they argue, they, do appeals, they request to the judges, they request to the other party. And this is the process through which the punishment is reduced. This is called as mitigation. The other word is mediation. Mediation is sometimes two parties, they want to decide their case outside of the court. So they appoint a third party to decide between themselves informally. For example, husband and wife, they fight and now they want to get divorced. So instead of going to the court, they go to an elder person, an old man, or a combined friend, mutual friend, and ask him to decide between themselves. This proceeding is happening outside of the court, and this is called as mediation. Sentence is the punishment. What judge says as a punishment, it is sentence. Appeal against conviction or sentence. If you are not satisfied, you think that you are wrongly being accused, or you are not satisfied with the sentence which is given to you, then you can appeal against it in the higher court. Structure of courts. Supreme Court is the superior most court. Verkhni Sood, I think you say it. And then there is a high court, court of appeal, court of criminal appeal. These are at regional levels. Yes, at regional levels these are. And then you have subordinate courts, magistrate court, magistrate, for small crimes, for punishment to the shopkeepers, for maintaining the cleanliness of the streets. Yes, to check if someone is selling some products like kartoshkas or pyaz on a very high price. So they control these sort of things. Yeah. District courts are, for example, Tashkent has so many districts, and each of these district has its own court. These are district courts. Juvenile courts means these are for children. Yes, juvenile courts are for children. The people who didn't have their passports or identity card, under the underage, you can say underage, 16 or 17, less than this, they, if they do some crimes, they go to the juvenile court. The judges decide, and then they send them to juvenile jails or rehabilitation centers. Coroner's court, these are also small courts in small localities. Sharia court is the religious court. They decide the case based on the law of religion. Yes, so in Islam we know that the Quran and Hadith and Fiqh and Ijtihad, these are 4 or 5 things in hierarchy. So we decide things based on this. This is called as Sharia court, in which the verdict is given according to the religion. In Islam we have Sharia court. In Christianity, for example, there is a terminology called as canon law. Canon. Canon is the law of the Bible. Law of the Bible. So in Islam we decide according to Sharia law, which is the law of the Quran. And if it is the law of the Bible in the Christian majority country, then it is called as canon law. And then you have family divisions. Family divisions, as I mentioned in my examples, that if there is a dispute between family, husband and wife want to get married, husband and wife want to get divorced, husband is not giving money to the wife, wife is not giving conjugational rights to the husband, they both have divorced and now they want to distribute the property, they want to distribute the children, who will keep children, who will not keep children. These sort of discussions, these sorts of disputes, these are resolved by the family division. Okay, so that was your lecture, ladies and gentlemen. Don't you feel shame that I have to give you lecture once again? Now the things are clear. Did you understand something? Are you there? Okay, you are the only one who is here. What about others? Okay. Okay. So, you have any question? Do you have any question? No? So, I want to do a small exercise with you. The main idea was doing this exercise was to get your feedback, to listen you speaking. So try to do your best while doing this exercise. Let me see, where is it? So ladies and gentlemen, you will think about one innovation. Do you know what is innovation? Innovation, invention. Have you heard about this word? Invention, innovation. Don't say that you don't know English. Think about one product which was discovered in this period. So I will divide you. How many we have now? We have 14. We have 14. So let's divide in two groups. Let me divide you in two groups. Okay. Okay. So the group one will select the time period 1970 to 1999, and the group two will take the period 2000 to 2019. So what you have to do, you have to think about a invention, a product, a process, anything which was invented during this period. Okay, did you understand? And it should not be, it should not be this steam engine, it should not be electricity, it should not be television, it should not be anything which is mentioned here. Okay, so be creative, think something different. Okay, so one product which was invented during this period, then what you will do, then try to answer these questions. What exactly was the innovation? When was the innovation made? Who made the innovation in which legal system? For example, civil law or common law. Why did they make the innovation? And the most important question is, how did the legal system have to respond to this innovation? What change in laws were required? Okay, so you will select a product which was invented in this period, which I will give you, and then you will answer to these questions: that what was this product, who made this, why they made this, and the most important thing is that what sort of changes our legal system has to do to accommodate the demands of this product. Did you understand? Did you understand the task? Ladies and gentlemen, hello.
Yeah, we understood.
Yes. So for example, let's take an example of e-commerce. E-commerce. So what is the invention? Invention is that people have starting buying and selling products on internet. Previously, they used to go to the physical shop to do the shopping. So when the e-commerce came, government has to think about the new laws related to buying and selling of product in cyberspace or on internet or through mobile application. And then they came up with the idea of e-commerce law. Now there is a business law and there is a separate e-commerce law which regulate the buying and selling of products in internet or cyberspace. Okay, so my invention is e-commerce, and what legal changes happened, that law had to think about new legal regime and the e-commerce was introduced. Okay, so now please, I'm going to divide you in two groups. Take 5 minutes, think about a product, think about the challenge to the legal system, and then we will share it with our colleagues. Okay.